Welcome, welcome, welcome. Today we're going to be looking at the lawsuit the New York Times filed against OpenAI in December of 2023. And the goal of this video is going to be to answer two questions. The first question is, what is this case about? And the second question we'll be answering is, why does this case even matter? And to answer those two questions, I did a few things. The first is that I read through all 69 pages of the New York Times complaint against OpenAI. And the other thing I did is that I read through opinion pieces, legal analysis, articles, Twitter threads, etc., so that I can communicate this as simply and clearly as possible. My goal is that you walk away from this video with an understanding of what this case is about, what it means for publishers, what it means for tech, and what it might mean for you. So let's get started and let's answer the first question. What is this case about? Well, this whole case kind of hinges on two words: fair use. And specifically, fair use in the context of copyright law. So the question being asked in this case is as follows. Is OpenAI's use of the New York Times content, specifically copyrighted content, is it fair use? And before we jump into the facts of the case, I want to take a quick detour and explain what is actually meant by fair use, specifically in the context of law. So as simply as possible, fair use is basically a legal principle that exists and says that you're allowed to use someone else's copyrighted work as long as the use is fair in the sense that it's being used for something new or different or educational. So it's actually the legal principle that allows people, for example, on YouTube, to splice in content from other media like TV shows and movies. And those TV shows and movies are copyrighted. There are copyright holders. There are some restrictions on fair use. So for example, you can't use too much of the copyrighted work, and you can't use it in a way that hurts the copyright holder's business. For example, it wouldn't be fair if you had a YouTube video and you injected a full-length movie in the middle of that video. At that point, you're depriving the studio of the revenue it could be making from streaming or renting out the movie. So I hope that makes sense. That, in a nutshell, is fair use. It's what fair use means in a legal context, at least in the US. So now that we've explained the concept of fair use and the basic question driving this case, I want to jump into the claims that each party is making. And for that, I want to start out with the claims by the New York Times. So what are some of the claims the New York Times is making in this case? So the most basic claim that the New York Times is making is that OpenAI used over 3 million of their articles for their training. And those articles are copyrighted. And so in doing that, OpenAI committed copyright infringement. So they're saying that OpenAI and Microsoft's large language models can generate output that recites Times content verbatim, closely summarizes it, and mimics its expressive style. In other words, it's taking content from the New York Times and giving it back word for word to users. And as part of this complaint, there's actually an exhibit that's part of it that has over 100 examples of what the New York Times is claiming is copyright infringement. So examples where the large language model is spitting back article pieces, paragraphs, sentences, etc. So that's the most basic and central claim the Times is making against OpenAI in this complaint. Another claim that they're making is that OpenAI disproportionately relied on their content to train their model. So there's actually a chart that the New York Times provides in this complaint that lists it as fourth in a list of sources that OpenAI used as being deemed credible or authoritative for the training of their model. And the chart's a little technical, but basically what it's saying is that OpenAI used the New York Times in a way that deemed it credible and authoritative, more so than many other sources. Those are two of the claims being made in this complaint. Another claim the Times is making is that OpenAI's training on their data has actually negatively impacted their business, their revenue, specifically in the form of lost subscriptions and lost advertising revenue. And there are a few specific examples the Times gives here. So one specific example is that OpenAI and Microsoft are driving traffic away from the Times because anyone who uses ChatGPT or Microsoft's Copilot feature will be presented with results that include content from the New York Times. And because this content is being fed to them through there, people are less likely to go to the Times website directly for access to the information, which means they're losing out on subscription and advertising revenue. And they claim that they're missing out on other revenue as well. So for example, the New York Times also has the Wirecutter, which reviews products and services for consumers. And part of the way they make money with the Wirecutter is through product commissions. In other words, driving clicks to affiliate links that people then use to make the purchase of the product directly. And because OpenAI and Microsoft include the Wirecutter's product reviews in their responses, people no longer have to go to the site to learn about the products or to make the purchase. And so they are losing out on these product commissions. And so if we take a step back here and look at what they're saying, the New York Times is saying that OpenAI hasn't just infringed on their copyright, but they've actually negatively affected their business. So those are the main claims being made by the Times in this complaint. And they're asking the court to hold OpenAI and Microsoft liable for billions of dollars in damage. And I actually want to give you some real numbers here. So how big could this case get in dollar terms? If a court were to find OpenAI and Microsoft guilty, on the lower end, they could award the New York Times $2 billion. That sounds like a lot of money, and it is, but it's not the absolute maximum that could be awarded here. On the high end, if a judge were to find them guilty of intentional copyright infringement, the New York Times could be awarded $450 billion. Let me say that again, $450 billion. Of course, there are a lot of ways that this case could go, but I just wanted to give you a sense of just how expensive this could get. We just went through the main claims being made by the New York Times in this complaint. Now, of course, we don't know what the lawyers for OpenAI are going to say specifically because it's too soon. But OpenAI actually published a blog post with a rebuttal of some of the claims the New York Times is making. And what we're going to do now is look at that rebuttal. We're going to understand what counterpoints OpenAI offers. So the first point in this blog post, which OpenAI published on January 8th of this year, is that they're already working with news organizations, and they're working with them constructively to craft partnerships and licensing agreements that allow them to train on their data. For example, OpenAI has already struck partnerships with Axel Springer and the Associated Press to use their content for training. And one of the things they say they'd like to do in the future is actually to evolve their model so that they can link directly to external sources so that people can read these articles themselves. The second point that OpenAI makes in this blog post is that training their models on publicly available data is fair use. And this fair use is actually widely supported. There are many examples of where and how this happens. And for those publishers that don't want their data being trained on, OpenAI has given them the ability to opt out, and that's something the New York Times has taken. The third point OpenAI makes in this blog post is an interesting one because it's a really pointed rebuttal against the New York Times claim that their model spitting out their articles word for word. I mentioned earlier that there's an exhibit attached to the complaint that lists 100 examples of times where ChatGPT spit out New York Times articles word for word. And OpenAI says pretty simply that this is just a bug. It's a bug that they've known about, and it's one that they're addressing right now. And they actually explain the bug. They say that when their model is being trained and certain content comes up over and over again, the model memorizes it. And because that content's memorized, when it's returned to the user, it is returned in a word-for-word fashion. But again, they say that they're aware, they're working on this, and they're going to get it fixed. Which to me begs the question, right? All those examples the Times provided around regurgitation of its content might be invalidated. The last point OpenAI makes in this blog post is a little spicy. Basically what they say is that the New York Times is two-faced. They claim that actually they were already in discussions with the New York Times to craft a partnership that would serve both parties. Here's how they say it exactly. OpenAI says that they were focused on a high-value partnership around real-time display with attribution in ChatGPT, in which the New York Times would gain a new way to connect with their existing and new readers, and our users would gain access to their reporting. And then they specifically mentioned that their last communication with the New York Times was on December 19th, and just 8 days later, on December 27th, the New York Times filed this complaint, which OpenAI says that they learned of the complaint by reading it on the New York Times. There are a few other points they say. So for example, one of the things they mention is that one of the ways you can get it to spit out articles word for word is by prompting them with specific pieces of the article. In other words, if you paste in the first paragraph of an article, maybe the subsequent paragraphs will be returned. We just walked through OpenAI's rebuttal to some of the claims the New York Times is making. And of course, they're not all legal rebuttals, but it is interesting that they're making a public case already. Now the question to be answered is, why does this case matter? Why does it matter for OpenAI? Why does it matter for the New York Times? And why does it matter to you? There are a few reasons. The first is that this case is testing the limits of copyright law in the context of artificial intelligence training. There aren't a ton of examples of this. This is fairly new, pioneering stuff. Of course, there are other cases which may be relevant, but again, this is pretty cutting edge. We just don't have a lot to go on. So in a legal sense, this case is pretty groundbreaking for that reason alone. The other reason this case matters actually relates to a point I made earlier in the video around how much the New York Times could be awarded. So if the New York Times were to win this case, it would probably result in the largest judgment ever awarded in dollar terms. That would be huge and potentially devastating to OpenAI and Microsoft. Two other reasons this case really matters. The way this case goes will actually have far-reaching effects, not just in the US, but Europe and elsewhere, in the way AI might be regulated. Regulations around training that could impact consumers, companies, and copyright holders in pretty meaningful ways. And of course, this means that the case will also impact the way generative AI companies train their models and make their money. Finally, this case is going to have really far-reaching consequences on publishers and media who make their money by monetizing their content. Of course, if OpenAI makes the case that using the Times content is fair use, it means that other AI companies will be able to train on the Times and other publishers' content without having to ask for permission or even necessarily pay. So it's not just journalists and publishers that might be impacted by this. It could also affect film, music, literature, and artists. So now the question you might be asking yourself is, how might this end? Well, no one really knows, but we do know that there are a few scenarios that are possible. As I mentioned, one scenario is that the New York Times is awarded damages in really significant terms. Another scenario is that the New York Times and OpenAI resolve this privately, so they take it out of the court system. It would be interesting to see that, just given that they had already been negotiating the terms of an agreement. An extremely unlikely scenario is that Congress steps in and actually legislates an answer to these questions, but that's extremely unlikely to happen for several reasons, among them that Congress just doesn't have a lot of political will to resolve anything right now, and this is really new and cutting-edge stuff. The reality is right now that OpenAI is kind of laying the groundwork for partnerships with media providers, and so that is likely what it's going to look like for other companies as well in the AI space. We don't know how this is going to end. There are a lot of possibilities, but it's going to have really far-reaching consequences for everyone involved. So that's a wrap for this video. I hope you enjoyed it. I hope you learned something. I know that I did, and I hope to see you in the next one.